Judgment has been reserved until Friday in the Western Cape High Court in the matter between the lobby group Afriforum and Parliament. Afriforum has made an urgent application aiming to suspend the adoption of the Constitutional Review Committee report paving the way for the amendment of Section 25 of the Constitution. The lobby group wants to interdict the report from being debated for possible adoption by the National Assembly on Tuesday, pending their substantive court application aiming to challenge the committee's process. This is, of course, all to do with expropriation without compensation. For more on this story, we speak now to our SABC reporter, Bulelani Phillip, who joins us now from Cape Town. Bulelani, this is, it's just one of those technical debates, I suppose. Afriforum are accused here of a bit of mischief because they're saying that it's now being said that, they flooded the process with as many applications as possible, but really all of them, or a lot of them, were saying the same thing.
Yeah, definitely, Bongani. Basically, what they are seeking from this court application that was heard today is an urgent interdict on the debate of the adoption of that Constitutional Review Committee report. Essentially, what the adoption means is that that report can now go before the National Assembly for adoption. And if that process is successful in the National Assembly on Tuesday, it would mean that Parliament would have to go through a process where they initiate another bill that would actually see to the drafting of the amendment of Section 25 of the Constitution, which would in fact give that effect of giving way to land expropriation without compensation. Now, what they want is that in their first relief, they are seeking that the High Court actually give them an interdict that that report by the Constitutional Review Committee must not be debated in the House on Tuesday, but thereafter they will be bringing another application where they want to actually argue more substantive issues which have also been raised in the first part of their relief. The substantive issues, of course, that they want to bring, I'll just highlight just two. What they're arguing is that out of the 600,000 odd written submissions that were placed before the committee, they found that in the report analysis is that about 176,000 of those applications were declared invalid on the grounds that they were duplicate. And they feel that that kind of decision is really invalid and illegal because it essentially excludes a lot of people that have participated in this process. But of course, on the other hand, Parliament has given a counter-argument to that argument, saying that they've analyzed those written submissions and found that all of them are actually duplicate in the sense that two people can submit a same written submissions to the committee, and they feel that only one would actually be valid. And in other instances, you'd find that there are institutions like the International Race Relations Institute, where there is a platform that is created for people to actually, in a way, sign petitions. But you'd find that because the petition speaks to the same issue, therefore that a lot of the people that participated in that process were seen to have been part and parcel of those submissions. So those are the two issues that the court has to actually find, a commonality or reason or judgment on when it comes to judgment tomorrow morning. The second issue that Afriforum has actually put before the court is that the service provider that was doing the analysis of all the written submissions is actually an indication that Parliament has actually outsourced its responsibilities, and they feel that they're actually abdicating their responsibility. But then on the other hand, the Legal Counsel for Parliament was arguing that this is not abnormal because there are instances where some legislations before Parliament are actually drafted by external experts, and the test of ensuring that Parliament does not abdicate their responsibilities, that any matter that is dealt by an outside service provider must be approved by a relevant parliamentary structure. So the judgment tomorrow will only be speaking to the urgency of the interdict that Afriforum is seeking. But of course, the bigger picture or the substantive court application will be heard at the later stage. But what the judgment as well will say or give an indication on is the timeline on which that particular substantive application must be dealt in.
Right, we'll have to leave it there. I mean, I suppose what it does speak to ultimately is the contestation of that process. We'll see what happens tomorrow. Judgment is reserved until then, when we'll get a decision, as you say, on the urgency. Bulelani Phillip there, our senior parliamentary correspondent in Cape Town. All right.